Here we go again. Convicted killer Lori Daybell back in court for her second trial in Arizona. This one is an attempted homicide case. The victim, her niece's ex-husband, Brandon Boudreaux. But this morning, the spotlight is on her attempts to avoid coming to court, which is kind of unlike Lori, right? The judge literally had to force her to show up after she said she was very ill.
The court finds that the court has not been provided any objective medical information of why the defendant can't proceed today. Although the defendant expressed that she has a headache and is not able to proceed, she was able to fully advocate on her own behalf and articulate to me the reasons why she doesn't think she can proceed and seems to be of sound mind and ability to proceed.
Lori, with her head on the desk, as you can see there on the counsel table, rather, is expected to return to court later today for the all-important opening statements. And remember, she's acting as her own lawyer, so she's choosing to give her own opening statement. Well, maybe she can choose to defer until after the state's case in chief if she wants, or defer it altogether and decide not to at that time. So, how does the judge handle someone like this? What's she going to do today? Is she going to come back in and continue to say that she's sick? And then what happens? What rights does she have? And how does the court have to protect those rights? We can't think of anybody better to ask these questions of than retired Chief Judge Belvin Perry, famously presided over the Casey Anthony trial. America fell in love with him, and we love him so much on this show, too. Judge, good morning. Thank you for being with us.
Good morning. How you doing?
Oh, wonderful. Thanks. All right. So got some questions for you. How does a judge handle a situation like this one?
Number one, in that particular case, in the defendant who's trying to play sick, you generally would have standby counsel. And the reason you would have standby counsel is just in case the defendant is feigning an illness, the trial won't be delayed. The court has to establish a record that the person, one, is doing this intentionally, that there's no basis to support the sickness, and then let standby counsel proceed with the case. Generally, courts will warn the defendant that if they act up or feign any type of illness, that it could have a detrimental effect, but it will not be cause for delay. So the key component is in this, in order not to delay the trial, is appointing standby counsel.
That's an excellent point. Right, Judge. Standby counsel. I wanted to ask you, please, about something else the court did in having the health unit at the local county jail do a comprehensive evaluation of Ms. Vallow and then provide a report to the court. How key is that for the judge in protecting himself in all this?
It's very important, because anything a judge does in a case of this nature has to be based upon facts, and the record must support it. If you can recall, in the Casey Anthony case, her attorneys during that weekend claimed they felt that she was incompetent. That left us scrambling Saturday and Sunday, getting competency examinations and having those reports back so we could start court Monday morning. So it's very important that the judge has some factual basis to back up his or her decisions.
Appreciate that, Judge. I'm so glad you mentioned that, because I'm sure so many of our wonderful courty friends watching at home remember that, and how sometimes you come to court in the morning, you don't know what kind of delay you could face for what reason. And Lori Daybell, at one point in time, some years ago, I believe in the year 2020 and maybe into 2021, she was deemed incompetent, but now she's back in business, as you know, Judge. She's got 4 homicide convictions under her belt. Thank God this victim on this instant case is alive, Brandon Boudreaux. Do you think that she may just not want to face him, Judge, because he is alive and knows so much, perhaps, about her?
That is so true. A lot of times defendants in these type of cases, it's easier to face a victim that is not there. But when you have a defendant a victim who has to face that defendant and the defendant face that victim, it brings about a lot of personal angst upon the defendant. So you're exactly right.
Judge, thank you for that insight. And folks should know you're in private practice now, doing a tremendous job. And so, you've done it all in the courtroom. You've been the advocate, you've been the judge. You certainly understand what kind of a dynamic can be created here. We have a clip of Brandon Boudreaux. He became a witness, as you're aware, Judge, in the case in Idaho. So let's go back to that clip. We can get a little bit of a sense of his testimony and how he might be in this Arizona case.
The window opened up and I saw a gun and a silencer. And I was my window shattered. I heard a bang, all kind of in the same amount of time. And my immediate thought was just, I'm getting shot at. And I, instead of turning my wheel and into my driveway, I just pushed the gas and drove straight.
Judge Perry, putting your lawyer hat on, your advocate hat, if you had Mr. Brandon Boudreaux as a witness to call, what do you think? Do you like what you see in terms of the way he's able to give testimony and recall the story?
I think his testimony was very powerful. It was not overly dramatic. It would tug at any juror's heartstrings. And he basically narrated an event and brought the jury there. Testimony should paint a picture. It should paint a picture of what that particular victim is going through. And those snippets there puts the jury there at the scene, really in his body, have an opportunity to experience what he was experiencing at that time.
Appreciate that, Judge. You're so right. Storytelling's all about transporting the jury or the judge, whomever's the fact finder, back into that event that's in question, taking them and making them feel something. You're so right. Tell me, what else are you thinking about as we get ready today for the opening statements? And Ms. Vallow wants to represent herself, and she also doesn't want this to happen today. What's on your mind, judges, that we all get ready for this?
The question is whether or not there are going to be fireworks. What can happen is she can come in, she can be a disruptor and cause or attempt to cause chaos, or she can come in and be as quiet as a lamb. Those are the two dynamics, and some things in between that the judge and the audience can expect to see. You can see from the snippets, she can be very engaging. She can be a little jovial. So the question is, who's going to actually show up today in court?
Oh, I love that, Judge. Which Lori are we going to get? Who knows? Buckle our seatbelts. It's all happening approximately 1 p.m. Eastern Time. The Honorable Belvin Perry, you're the best. Thank you so much for being on the program this morning.
Thanks for having me.
Of course. Hope to see you again soon.